Hey, good afternoon, everybody. It's Leo Jacobs of Jacobs PC. We're back for another podcast, and we have some very special guests today. But before we get into them, I wanted to thank Club Macanudo on 63rd Street in Madison for sponsoring this cigar series. For all those out there that want to know what I'm smoking, it is a Davidoff Year of the Dragon. It is an excellent cigar, and I have some friends that have joined me today. One of them being Yuri Itsakov from Nano. Welcome.
Thank you.
It's a pleasure to have you here. Tell us what you're smoking real quick.
We're smoking a very unique Davidoff 10-year anniversary limited edition.
Yes, it's a Nicaraguan cigar.
Nicaraguan cigar. It's very smooth and delicious. And
Our other guest here today is Wayne Greenwald. Wayne, say hello.
Hello, everybody. Thanks for joining us.
It's a pleasure to have you. He is our senior counsel in the bankruptcy department. He is a statesman. He is a professor. He is someone that his publishers apparently like, okay, and say that he knows his stuff in bankruptcy. And we'll be talking about that a lot today. So, Wayne, thank you very much for joining us.
Thank you for having me. Rumor has it I also know something about cigars.
Tell us what you're smoking.
I'm smoking a Cuban Crafters Salomon, which is the size of a cigar. It's a Nicaraguan. As you can see, it's got interesting X's on it. It's a multi-wrapper, very smooth, very nice. Like it a lot.
Very cool. Very cool. Well, thank you for joining us. We have another special guest today. It's our senior associate, Adam Sherman. We're very, very happy to have him here today.
Thank you for having me. Good afternoon.
All right. And what are you smoking?
Why don't you tell me?
It is also a Davidoff Nicaragua 10-year anniversary. Let's talk about why we're here. We're here to talk about specifically business divorce. Business divorce is an umbrella term. And some of the topics we're going to discuss today is partnership disputes, vendor disputes, shareholder disputes, officers, director disputes, all types of disputes that fall under the umbrella of business divorce. We have a big construction litigation matter. You know, don't talk about the motions or what we filed, but talk about the characters and the personalities and, you know, what's the objectives? What are they about? Talk to us.
So really, every client has their own unique perspective, objectives of what they want to do. But for those specific cases, the first issue, which we actually spent a lot of time dealing with, which I actually think kind of gets looked over when you think about partnership disputes, is which form you want to go to.
Interesting. So tell us, what does that mean? What does that mean?
So that is where the dispute is going to be decided.
You're telling me that we can have different places to fight?
Absolutely.
And where are those places? Tell us where they are.
In federal court, it's a little harder because there's only two ways to get there: federal question jurisdiction or diversity.
Which is where you're from two different states or you're national, right? And the dispute is over $75,000. What's the other way?
Federal question, if you have actual federal claim. We have a case where we're dealing with False Claims Act jurisdiction, where you have a claim under a federal statute, and then you can jump the line and get to the big boy court. Depending on where you want to go, you have state courts of New York, where we go every day, which are incredibly busy, slow, but can be fast if you know the right way.
Let's call that the first floor. Then there's the second floor.
Without it disrespecting the state courts in New York, you have federal court, the expensive looking courtrooms, judges that are nominated by the judiciary. They have their stellar resumes, et cetera, et cetera. Not disrespecting the judges in the state.
No, absolutely not. We love our state judges.
Very well.
In real estate, interest rates are up, laws are changing, credit markets are tight. You're coming up to your partner and you're telling your partner, hey, partner, you got to give me an equity call. And the other partner turns around to you and he says, I don't have the money. Go borrow it. And he says, well, the credit markets are tight right now. Can you go borrow from your uncle or somewhere else? Can you find the fine? He's like, no, I can't. Well, you promised me that you're going to get that for me. Well, I can't. It's a tight market. And that's where resentment starts building up. And all of a sudden, your partner, you were friends, you were eating at the same dinner parties, is no longer talking to you. Those personalities start dividing. How is the market affecting those relationships? Business divorce can span all types of industries. It can span energy. It can span retail. It could span manufacturing. It could span real estate. It could span aerospace law. So business divorce is a practice area, and it's industry agnostic. And industry agnostic is a fancy way of saying
description.
it doesn't discriminate. Business divorces happen in all walks of industry, in all walks of people and life. Okay, and that's important to know.
When you create your entity, you're going to wind up with an operating agreement or shareholder agreement to determine and define the responsibilities of the partners in terms of who's going to be responsible for what. There may be equal responsibilities for capital. There may be one partner who's basically going to be the funder and another partner is going to be the operator. You have to first go look at the partnership agreement to see which one of the partners feels that they're being oppressed by the other partner saying, well, you're asking me to do what I was never expected to do.
That's the rub. I call that the rub.
That's the interpersonal problem. You then wind up with, okay, here we have the entity that needs the money.
Which is separate from the entrepreneurs who are the partners.
Yes and no, because the entity needs the money and the partners need the entity as well. And if the entity isn't operating, the partners are facing liability and risk, so that if it falls apart, they're going to be losing their investment. They need to work together. And if they can't work together, they have to figure out what are they going to do to bring in money. It's driven by the documents that are the foundation of the partnership or the entity. Generally, if you can't get a lender, maybe there's an investor involved you can do. It may be necessary to sell the business and see if you can make money on the sale. But there are many ways of dealing with the problem. To some degree or a great degree, requires flexibility and creativity on the part of the partners, shareholders, whatever, to determine how do we define the problem and how can we solve the problem. Now, this may involve bringing in all kinds of new people. Bringing in a lender would be wonderful if everybody can agree.
There were two partners. One was 51%, the other was 49%. One of the partners got their license suspended. It was a dealership license. All of a sudden, one of the partners, in our view, took advantage of that and kicked him out and went to court, ran to court, got a few temporary restraining orders, and even put that person's shares into a trust until matters are resolved.
This is like the textbook example of how you do not want to conduct a partnership, where you have documents that set forth the obligations of both shareholders, and then you have instances of, you know what, we're just going to do things this way, and that will be okay for now.
They had a 100, 200, $300 million business in secondhand automobiles. We're talking about Bentleys, Rolls Royces, Ferraris. I think both of them were driving Ferraris. Both were riding Rolls Royces. They couldn't stand each other anymore because their views differed on management. So the business is making money.
Very successful.
Very successful. We're talking about multiple digit millions. It wasn't a case of greed. It was a case of different perspectives. One of the visionaries, or the partner, counterpart, was much younger than him. Okay, he was in his 30s. This guy was in his 40s or 50s. He actually caught cancer, unfortunately. And he saw this individual as someone that he can envision running his empire that he built out of scratch. This guy could have put two pennies together 10 years ago. But now he was this very successful man. He found someone that can take over, and he put him as the managing member. Unfortunately, in our view, that person took a little bit of advantage. He didn't take advantage because they were doing bad business. He took advantage because he just didn't like our client's management style. Their partnership was extremely, I'd say, incestuous in terms of putting piles of money together and purchasing real estate with it. He thought our client was spending too much money, leveraging too much money. And the first shot that he got when our client was in the midst of selling his other business, that other business got into some turmoil. As a consequence of that, our client's license was in danger. And as a consequence of that, the partnership was in danger as well. Because if you lose your license here, you might lose your license here. And unfortunately, instead of coming up to his partner and saying, hey, let's work together, his partner decided to go to court, to run to court. In partnership disputes, there's oftentimes, and tell me if you disagree or tell me if you disagree, there's always a crossroads. Do you go the route of coming up to your partner and telling your partner, hey, we should work this out? Or do you come up to your partner and say, I'm going to litigate and I'm going to kick you out? And I think that there is a misconception that partnerships break up because it's not making money, the market is down, basically ancillary causes.
Partnership divorces, like marital divorces, some of what must be done at the very, very beginning is anticipating the possible end and the problems that can develop. You frequently have antenuptial agreements between people who are getting married, and it decides that in the event we divorce, this is what will happen. These are how the assets will be divided. This is what will occur. And this can happen at the very beginning of a partnership agreement, saying we have the ability to go on, take our monies and do things that are unrelated to our business. And if we do, that is not your business. You can, at the very beginning, define what the limits of the relationship are and the boundaries of intrusion from one partner to the other are. And then say, in the event we have a disagreement, we can develop a mechanism for dealing with that disagreement.
We're talking about hundreds of millions of dollars.
Understood. But anybody with business experience, which hopefully the partners have.
These guys barely had operating agreements. They had counselors. And you would think people are looking like, oh, well, I'm all sophisticated. No, big partnerships in the billions, in the hundreds of millions are sometimes done on the back of paper napkins. That's why lawyers exist.
So when partnerships come together, people are very excited.
Oh, the vision, the stars and the
vision, the
moon
star-
align. You don't say, hey, let's lawyer up. That's extremely sophisticated. Downtown at Cipriani's, you write it back in the this is going to be a $100 million, $2 billion business. And then you give it to your lawyers. That's not how business works.
I don't think lawyering up is sophisticated. I think lawyering up is a knee-jerk reaction. Sophisticated reaction is, we have a problem. Identify the problem. How can we solve it? And maybe we can't solve it ourselves directly.
The way I would approach it is you would say, look, we want to open up a theme park and we have to get investors. We have to get the proper vendors. How are we going to do that? What is our goal? And then you say, how do you see you and I working? What if this doesn't work? Why don't we put mechanisms in place?
Exactly.
And some of the mechanisms that we would recommend our clients is, if we can't agree, you have to go to, non-binding mediation. If non-binding mediation doesn't work, we agree to some type of relief or a third party that would handle the affairs ahead of time instead of going to court and asking for a receivership or asking for a third party agent or a fiscal agent, which is what happened in the automobile case.
That's what wound up happening. Yeah. Really, being a managing member in several LLCs gave the other guy a big advantage in terms of running the court, saying, I'm the managing member, I can dictate what's going on. This other guy has a major problem. There's going to be a domino effect. I need to appoint a professional really to preserve the business because we can't run it together. Give the elephant in the room here.
Right. And the difficulty in that case was really the fact that he didn't want him to be his partner anymore. Partners sometimes simply fall out of love. It is a marriage. Mm-hmm. It is something that you have to bring up the topics of how are we going to deal with disagreements.
So I will add one thing. There's no false divorce in matrimonial courts. It's not the same thing in partnership disputes.
Always somebody's fault.
A court will attribute fault to a partner in a partnership. If you have clear evidence that partner is not acting in the best interest of the partnership, that's kind of Jacobs PC's bread and butter.
Let's talk about the two doctors. There were two partners. They were running a medical office. One of the partners already had a Bronx office. That Bronx office was run by the partner's wife. We're talking about a few $1 million business. Everything is doing all right. Everything's doing okay. One of the employees finds out that the partner is sending patients to that other office. So invariably siphoning funds away from this business. And not only that, this company in Bronx, and we'll put this one in Brooklyn, is under audit. And that the other partner is doing what to the books and audits, Adam? What is he doing?
I mean, we'll put it lightly, cooking. Yeah.
This person is literally doctoring audit papers. It's just not good. Our client, the way he finds out about it is that rogue employee who got fired by the partner who's committing these alleged act. She calls the other partner and she says, this person committed malpractice on my husband through services that partner actually committed. And now the malpractice carrier is investigating it. So that's a direct reason to break up a partnership, right?
So this was a real precarious situation because on one hand, our client was relatively blameless. The issue really becomes if any of this comes to light, what's going to happen to the license that the person holds? That became our paramount concern in terms of resolving it efficiently in a way that protects this person's livelihood.
And I want to highlight something. For all the partners out there that think that their partner's mess is not their mess, I got another thing to tell you. When your partner's doing something bad to the business, he or she is breaching its fiduciary duty to the company. And if you allow that partner to siphon funds, audit books, doctor books, over leverage the company, fire people, and mismanage, and you close your eyes, well, guess what? You are exactly, joint and severally liable, absent an operating agreement saying otherwise. He came to us and he said, what did he say to you, Adam? What did he say? He's like, look, tell us what he said.
Look what's going on here. This is open and shut. We got it.
Yeah.
And our response was, hold on. Hold on, you got it.
Yeah.
Maybe
Tell us more.
Maybe you don't got it. Maybe we need to resolve this so you're okay. So you can continue practicing years down the line.
And the client didn't really understand that.
No, he didn't appreciate that advice though.
And why is that? And why is that?
I think it took a few months of, understanding that he may have had independent duty to report. He may have a duty to correct. While your hands are clean, they're not scrubbed down clean.
And they're not clean at all, actually. They're pretty dirty. And that instructed our litigation strategy.
The business is dying through no fault of ours. It's just not working. And we, as the members, may have guaranteed the obligations, such as signing guarantees, or we may be on the hook as a result of statutory liability, such as being on the hook to pay sales tax or employee benefits. And we've got to go figure this thing out. So you then wind up with pointing fingers. Oh, you were responsible for this. No, you were responsible for this. So that way you wind up with another form of dispute where there's really no fault on either part, except the business couldn't make it, just poorly run. The business isn't surviving. You look at all the restaurants that died as a result of COVID, possibly through nobody's fault except the virus.
So that's very valuable what you say. When partnership disputes occur, grieving is part of that process. But what do you grieve, Wayne? You're grieving the business. You're grieving the business.
Well, as I talk to people whose businesses are failing, to some degree, a business is your child. You've invested a great deal of your life and your fortune to make this entity, because even the Supreme Court says a corporation is a separate entity. It's a separate person. You've invested a great deal into making this thing thrive, live, develop. And when it dies or is dying, you will grieve. I have had clients who really considering taking their own lives as a result of their grief. Frequently what I will say to somebody, we're going to work on the finances, but you've also got to do something to work on yourself, because we need you here for this process, and I need you here in your head too.
When things are failing, you tend to blame your partner. You tend to blame your vendor. You tend to blame your shareholder. You tend to blame your employees. So the distribution of fiduciary responsibility and the distribution of responsibility to yourself onto others becomes a very important part of partnership dispute management. And that's one thing people don't really talk about, is how do you redistribute that management and those responsibilities when you're in a partnership dispute? Because you know what typically happens? They start pointing fingers and everybody lawyers up, and the only people that make money are the lawyers and the accountants and the consultants and the appraisers and the valuators, and all of the vendors that were not supposed to make money are now making that money. What are the first 3 or 4 steps one should take when they're feeling resentment, partnerships not working out, what should they do?
I say start talking to each other. If they're not talking to each other, then it's really hard to solve the problem without a third party coming in.
Would you recommend a lawyer, a mediator, a cousin?
I would generally recommend a mediator, and hopefully, when we talked about at the very beginning, in the partnership agreement, in the shareholder agreement, in the event there's a dispute, we automatically go to this agency, this person who will act as the mediator to deal with it. That way, we don't have to go pointing fingers anymore. We know who's going to come help solve the problem.
And if that doesn't work,
Lawyer up, and you start fighting.
The business is in jeopardy. And as a result of the business being in jeopardy, the equity holders have to go deal with each other. But if they're not dealing with each other, then what do? And here you have an equity holder who has about 45%, and then you have another equity holder who has 55%, and the 55% shareholder doesn't want to do anything. As a matter of fact, the 55% shareholder is a shill for a third party who has actually siphoned money away from the company. What has to be done to protect the company? At one point, we're talking about suing that 55% shareholder and the person who's taking the money out. And we're also considering the possibility of a bankruptcy for the entity to bring the money back in, and or look for third-party financing to come in to revive the company, or ultimately selling the company to a third party to resolve the problem for everybody and potentially have a new future for the shareholder who is not screwing things up.
shareholders are looking at the performance of the directors and the officers that are conducting the business. And sometimes shareholders could be those that are working in the business. In this particular case, a shareholder has partaken in the minutia of the business.
Yep.
But then there are shareholders such as REITs, investment funds, hedge funds, private equity funds that take capital and institute their business judgment into an industry. A lot of REITs, real estate investment trusts, have for a very, very long time been extremely successful in deploying their capital of their shareholders and as shareholders to operators such as partners in certain regions of the country, of the state, cities, and all over the world. And they've made and placed their bets, but they have fallen short. And now those shareholders that the REIT is taking care of or providing investment returns to are on an uproar because of the market, specifically the industries of trucking. Logistics is doing poorly in certain regions. Real estate is surely doing very poor. Retail is doing very, very poor. And restaurants are doing hospitality is doing a bit poorly right now. Those shareholders are now not going after the operators because they're removed from the operators of the business. They're going after the management team, which are the directors and the officers. The operators are operating, I guess, on a more macro level. They're looking at the operators as returns on their investment. So think of partnership as the first level, shareholders looking at the partners, right? And then hedge funds holding certain specific holding companies that are industry specific. So we have retail, hospitality, real estate, et cetera, et cetera. Shareholder derivative actions, Wayne, are very important actions because they describe the breaches of the management team in those specific regions and industries. Think of it as a greater collective or a greater body of capital that was employed into the industry and now is failing. One of the gleaming examples of that is real estate investment trusts. Real estate investment trusts deploy their capital into, say, the New York City region, right, into residential multifamily space. And now the REITs are going bankrupt. What the REITs are experiencing is their shareholders questioning the business judgment of the management teams and saying, hey, what the hell were you doing putting all of your eggs in one basket? Why did you only buy multifamily? Well, multifamily has been a very safe bet. Or why did you put it all into retail and invest it into one company? So now shareholders want answers Do you think we'll see a lot more shareholder derivative actions or shareholder actions given the market and the state of the economy and the industry specific regions that I've stated? Retail, hospitality, real estate, trucking, logistics.
I can't say.
Okay.
It all depends on the viability of the entities. If the entities remain viable, then I think you may be looking at shareholder derivative actions because people are saying, I'm not getting the money I should, as opposed to where the business is failing. A business fails because for one reason or another, it is not making the money that is necessary to keep it alive.
Shareholders look at something different. They're looking at purely returns, whereas the partner is looking to create their vision.
Everybody's looking for profit.
I think it's, as Wayne stated earlier, as to the main reason why there's a lot of business divorces. I think the same applies to shareholders. It's personality driven. And also, I want to make clear that in a shareholder derivative case or any derivative lawsuit, you're required to show that you actually tried to work it out. Cases are routinely dismissed for failure to do that sufficiently. You really have to make an effort to resolve it before going to court.
What is the size of the corporation? Are we dealing with a closely held corporation or a corporation with lots of shareholders? They each have different dynamics. When you're dealing with entities with lots of shareholders, you're generally dealing with public corporation, which cause their shares to go out to the public. And you may wind up with dissatisfied shareholders while the company may be making money and they're saying, well, something's going wrong. And they, on behalf of the company and or other shareholders, do a shareholder derivative action. That's generally looking at the large place. And the company can be doing well there. Then in contrast, you've got a smaller entity where the business factors reverberate more for the equity holders, whether they're partners or whether they're shareholders. The result is the same. And if one is holding the other or others accountable, then we'll commence an action if they can't resolve it.
Does business divorce really get at litigating? Is that what it's equivocating to? Or is it equivocating to separation agreements, buyout agreements, wind down of divisions? What is business divorce? I think we've all been talking about business divorce as ending in litigation.
We started off saying lawyering up is a knee-jerk reaction.
Right.
Looking at other means is the smart approach, such as buyout agreements, such as separation agreements. Here you have people who are looking at the business problem as opposed to the litigation problem. Success in business litigation depends upon which word you put the emphasis. Emphasis? Emphasis. You can put the emphasis on the word business or put the emphasis on the word litigation.
Right.
If you put the emphasis on the word business, then you'll be looking for an intelligent solution dealing with money, which will ultimately be productive. If you put the emphasis on litigation, then it may be years before you see a satisfactory resolution.
What partners and shareholders and vendors do is they point at each other, but they don't point at the business. And pointing at the business is extremely important. And saying, you know what? Yes, Philip or Joe promised me this would happen, but is it the market? Is it really what Phil or Joe is doing? Do we need to divest ourselves of this division? The donuts that we created, or the bicycle that we manufactured, or the cars that we bought, or the medical office that we're running that's not working in certain places? Or should I look to the person? So don't look only at your partner. Look to the business, and from there, you can intelligently understand whether you need to divest from the business or you need to divest from the person.
The business is suffering. Okay, how is the business suffering? The business suffering because of cash flow? Or is the business suffering because it's not making money? Is the business suffering because money it's making is being siphoned out? We have to figure out what are the symptoms. Then we figure out what is causing the symptoms. It's just like when you're sick. Is it a heart attack or is it heartburn?
Exactly.
Then you go, okay, it's heartburn. I can do something, just take a couple of Tums or antacids. If it's heart attack, I got to do something more radical.
If you are the partner that believes it's time to initiate the separation, you should also look at yourself as to why you want to do that, beyond dollars and cents.
Right. And that doesn't really happen because decisions at the highest levels, and we're talking about billion-dollar businesses, hundreds of millions of dollars, they're really personality driven and emotionally driven. And I think that why there's so much acrimony in business divorce is because our clients are looking to one-up each other instead of work with each other against each other. Yes, business disputes are going to arise, but where they derive from is oftentimes misunderstood, not communicated well, and done for reasons that are not intellectual, but emotionally charging. There's the CEO, there's the board, which controls which way that CEO goes. And then there are the shareholders. Shareholders control or are represented by the board. The board controls the management team. The board is looking to the shareholders to drive shareholder value. The CEO is looking to the board to say, this is my vision. Can you agree with my vision? In the Sam Altman debacle, Sam had a vision, the board had a vision, and the shareholders had a say to drive revenue. The board and the CEO did not agree. The board ousted the CEO. The CEO came back because of employee sentiment and shareholder sentiment. The CEO's vision and the board's vision did not match up. Sam Altman, if we were giving him advice, we would say, did you breach your fiduciary duty? Did you follow the protocol in the policy? Were you communicated that properly? Did the board act outside their protocols? And if we were representing the board, we would ask the board the same exact questions. And then we would go to the shareholders and ask the shareholders about the board. And did the board mess up anywhere?
All too frequently, shareholders are sheep. They will rely upon the boards. The board is responsible to the shareholders, and the shareholders can oust board members, and the board ultimately does the CEO. But the shareholders are generally only interested in one thing: price of shares going up and dividends.
Right.
And ultimately, it is the board who is concerned about how those are reacting. But the shareholder has very, very little control over that. The market does have control over it, because if the price is going down, shareholders will sell their shares, and that will come up with a response by management. But shareholders on their own have really very little say in terms of what happens to the company.
Sam Altman was probably very, very interested in understanding employee sentiment, retention, vision for the company, as well as what the consumer is thinking.
This whole situation is an incredibly unique fact pattern that probably won't be repeated until they release a new season of Succession. You really don't see what happened. Everything that comes out in terms of these press releases is heavily edited and presented in a way to tone down the internal fighting to help the company. I would guess that there's a lot of factors within that boardroom that none of us know about.
Family disputes are extremely emotionally charged and sometimes take a life onto themselves. There is no reason in family disputes. It's out of reason. It's extremely emotional. Family disputes should not be lawyered up until the rabbi, the priest, the cousin, the mother get involved. And it's oftentimes over a piece of real estate when someone dies. It's over some shares. When I talk about family disputes, I'm talking about actual divorce of your husband that creates a business divorce, right? And we're talking about family disputes. It's actual divorce between husband and wife, husband and husband. We're also talking about estates litigation.
Unfortunately, I'm familiar with a monster family dispute, which ultimately resulted from 2 divorces. The acrimony that resulted from the divorces then had impact on the economics that were involved. And you wound up with people taking polar positions and just fighting. To some degree, it's not a matter of what's right, what's wrong, what is beneficial. It's a matter of this is what I want. Reason leaves the room and feelings and emotions govern.
And occupy.
And unfortunately, there is not much you can do about that.
You had a grandparent and 2 brothers where one brother was much more of a dominant figure than the other one. The grandmother was getting sick. The grandmother has lots of assets, millions of dollars worth, who's getting what. And of course, the grandmother in the situation wanted the dominant brother to control the assets. The more passive but still intelligent brother wasn't happy with that picture because there's two brothers. Why can't it be 50-50?
Exactly. And that's another touch point, which is a very good example about ego, responsibility, or the thought of I'm more responsible and you're more inferior or I'm more superior, which is another beast of its own, estates litigation and family disputes, which are a different breed animal of business divorce.
I'll mention a family litigation that I dealt with in the past. This was all kind of one big family where, you know.
Once upon a time, there was a family. They had a family business. 3 brothers, and there was a mother involved. And the mother basically acted as the intermediary, and one of the brothers also was a neutral. Mom died, as did one of the brothers. That left 2 remaining brothers who were fighting over literally 3% of the business. 3% of the business and who controlled it. The issue of who's right, who's wrong, who did right to me, who did wrong to me, who's the bad guy, who's the good guy. The 2 of them could not get over it. The lawyers were the ones who were trying to deal with this on the business level to say, hey, there's a business resolution to this. Stop fighting.
And they didn't care.
One of them ultimately did care, and then he was the first to die. But they hardly cared. And the business could have been completely resolved, but they were just too angry with each other to deal with it.
Joint ventures is unlike partnership disputes where it's we would do this together and we like each other and we have the same vision. Nike enters into a joint venture with Keith and they are creating a brand. Those are 2 independent standing participants in a market that want to cross brand. Or Related takes a building and recapitalizes it with JP Morgan. Those are joint ventures that can go wrong. The concepts are still the same, maybe a lot less emotion. Oftentimes, all of these things that we talk about often are encapsulated in those joint ventures. In terms of sophistication and lawyering up, even they get into disputes. And those disputes are typically purely money. So the 3 legs of the stool is family and estates litigation, corporations closely held and larger corporations, and then joint ventures. They're 2 vendors that are serving consumers of a market. And they get into disputes, which is different from partners, which is because it's closely held, and different from family. It's not family. Market makers in real estate, for example, Gucci gives money to Louis Vuitton, or Louis Vuitton gives money to Gucci to build out a space. Definitely obligation-driven and contractual form. And that will be the side of what's called vendor disputes, where there are 2 vendors looking at a consumer or a product, and they get into a dispute. And what's valuable to understand in that scenario is
I generally view joint ventures as partnerships. They're just a different breed.
I agree with that, but I also want to add one more thing, kind of a way to prevent business divorces. It's really like the first partner or shareholder that wants to do something that could result in a lawsuit. Before that step is taken, some type of mechanism in terms of speaking to your other partners, a mediator, someone who's not financially invested in the outcome. That's really the moment where it's either going to explode, it's going to be resolved, or it's going to go in a path that you can't see.
we do mediation as well. We mediate disputes all the time. If you believe that your partnership or your joint venture or your family estate litigation is cause of your acrimony, pay your lawyer for 6 months and see how much money you lose in legal fees. It'll be more acrimonious because then you have to figure out who pays for that. So to everybody there, instituting preventative measures by encapsulating mediative methods, third parties, people that can resolve matters. And if that doesn't work, instituting the proper forum in which to litigate, which is the first floor, which is the state, the second floor, which is the federal court, and say the mezzanine, which is bankruptcy. Those are the forums.
There is a 4th form, arbitration, and you can also have mediation as well.
Right.
Basically a forum for resolution, not for confrontation.
If that doesn't work, while there are places and reasons to litigate and questions to litigate, make sure they are flushed out by your counselors to make sure that whatever you do fight about is definitive, dispositive, and can yield you leverage or an actual result. Thank you, everybody, for joining me today for our podcast.
Thanks for the
series.
invite. It's fun.
It was very, very nice. We had fun. We smoked some cigars. Had a very interesting conversation. And to next time, everybody. We thank Club Macanudo. We thank Davidoff. We thank Nano for producing the content. Our fun guests today, Wayne, Adam. We appreciate you. Till next time, everyone. Thank you.